We've got good news today. We've got an expert immigration lawyer in the house who will be able to put to bed a lot of the anxiety and questions that you have. Laurencia, without wasting the audience's time, can you please introduce yourself?
Thank you very much, and thank you for having me here today again. I'm Laurencia Kwijiraful, and I specialize in UK immigration law. I'm a qualified solicitor in the United Kingdom currently. Thank you.
Thank you, Laurencia. So the first question that we have today is for someone who, or for people who move to the UK and by early next year, they will have lived in the UK on the work visa for 5 years. Can they apply for indefinite leave to remain?
Now, before I answer that question, let me just put in a quick disclaimer. Now, this session is intended to give general information on current UK immigration law and recent updates. It does not create a solicitor-client relationship, nor does it provide legal advice on any specific matter. Case examples used are for illustration purposes only and may not apply to your circumstance. Now, immigration rules do evolve and change very quickly. Now, it's always important, very, very important, to seek legal advice in relation to a specific personal advice. Now, our details will be put on the system. So if you want personalized advice, you can always give us a call back. But this is basically to give you general information. Thank you. Now, with that question, it depends on the visa route that that person is on. So let's say if you are in the United Kingdom as an economic migrant, let's say under the skilled worker visa, currently you can apply for indefinite leave to remain after you spend 5 years lawfully in this country. So if, for instance, you reach 5 years, okay, in February, what you have to do is put in your application immediately, provided, okay, you satisfy all the requirements of the rules, all the other requirements of the rules. It's important to state that people must comply with the conditions attached to their leave to remain. So that is for economic migrants, those under the skilled worker visa. Now, I'll also talk about those on Appendix FM. So if you entered into the country on, let's say, as a spouse of a settled person, you are either put on the 5-year route or on the 10-year route to settlement. So if you're already on the 5-year route to settlement and that would end in, let's say, February, yes, you can continue to make your application for indefinite leave to remain. If the 10 years reaches February, you can do the application and you should be all right. So it depends on the visa route that you are on. Insofar as the rules have not changed, you can still make an application if you've accrued the number of years relevant to a particular application.
Thank you very much for that. So with the recent proposal that the Home Secretary announced, when are they likely to come into effect?
Now, but the Home Secretary's proposals in relation to the indefinite leave to remain, it's not currently in law. They haven't stated specifically when it's going to become law. What they've done is they've stated that it's currently on a consultation stage. So that basically means they are consulting stakeholders, those who will be affected. What I'm telling people is that you can, if it's going to affect you and you're a migrant, you can book an appointment to go and speak to your local member of parliament. Now, the Home Secretary made it clear that they are willing to listen. Now, people should speak to their members of parliament, let them know how this is going to affect them. Now, the consultation is likely it's going to end around February. That's what they are suggesting. But then we don't know what is going to happen after that. It may now become law or not, depending on the outcome of the consultation and the outcome of the consultation in relation to what happens to the proposals that she's put across.
So you heard from an expert immigration lawyer saying that you can book an appointment to speak to your MP, explaining how the policies that are being proposed, if it comes into effect, how it will affect you. There is a link, and I've always advocated that our people need to use this route to try influence government policy. There is a link here. I will leave Laurencia's contact details shortly. This is very, very important update. Laurencia, another thing I want to ask you is that someone who came to the UK, and they have now reached the point. Let's look at the student now. The recent changes, how would it affect students and those on the care workers visas?
Now, if we are talking, there has been several changes. So I think I have to clarify this. Okay, there has been several changes. Yes, the proposal, I think, is about three things happening currently. The rules that has already been implemented. So the rules that are already in effect, the rules that have got specific future dates in which it will be implemented, and the proposals of the Home Secretary. So, for instance, we know that dependent of students, they've introduce restrictions and stuff like that. The English language requirement is increasing in January 2026. The graduate route is going to be reduced from the 2 years to the 18 months. Okay, so all these ones basically are things that are going to happen, that have got future dates. Now, with the proposals, they are currently not law. So of course, that one people can just kind of relax about that one. But it's important for people to know what has happened, what is going to happen in future, and what is deemed to be proposals. Now, with students and the skilled workers, if these proposals, which is for the indefinite leave to remain, come into effect, now it's going to affect them. The thing, what is happening is they haven't said that they are not going to, they are only going to, like, they haven't stated, normally when rules come into effect, it's not applied retrospectively. But with this particular one, they haven't said anything like that. So that means it could apply retrospectively, in that if you haven't applied for settlement at that time, it can affect you. Okay, so students, healthcare workers, and all those people should take into consideration this. They should be seeking legal advice, keep themselves updated. Now, with the care worker people, they are saying that the period that you have to accrue before you settle is going to increase to up to 15 years. But I always tell people, always see the positive in things. Now, if you are here as a care worker, they've put into place certain things in the proposal that if, let's say, you speak English language to a very high level, okay, what is going to happen is going to reduce the number of years you would have to accrue before you get indefinite leave to remain. Now, depending on your set skills, if you are a care worker and let's say you train or retrain to become a nurse, for instance, now that could also shorten the period. So people should think of upscaling, like improving on yourselves, doing voluntary work. All those ones have been considered. And most importantly, do not commit any crime. I always say this, as much as depends on you, follow the rules. As much as depends on you, follow the rules, because as the rules changes, as these things keep changing, it would prolong your period for you to get indefinite leave to remain. So if you can obey the rules, do what is right, then of course, there are other ways to go about reducing the time period of getting indefinite leave to remain.
So does that mean someone who came on a care workers visa wouldn't, if they do the things that you said, they've upgraded themselves in terms of English language, there is the possibility of them getting indefinite leave to remain without waiting for 15 years?
Now, when you look at the proposals, so let me give an example. When you look at the proposal, they said nurses and doctors, okay, are going to get indefinite leave to remain more likely after 5 years. Okay, so if you're here as a care worker and they've said, okay, you are going to get indefinite leave to remain after 15 years, okay, that is what is in the proposals. No one knows what is going to happen. It's not law yet, so it's not conclusive. Now, if you want to kind of upscale and now retrain to become a nurse, then instead of waiting for that 15 years, then of course you can now apply for indefinite leave to remain after 5 years.
So can I just clarify that it doesn't have to be nurse. Anyone that work in the public sector also can get indefinite leave to remain in less than 15 years. Is that correct?
Now, it depends. It's important to be careful here because these are proposals. Now, the specific ones that she used was nurses and doctors, but there are other highly skilled routes. Okay, so something like global talent, like the global talent route, for instance. Okay, all those ones, their period will be reduced. So it depends on which one that you go for. But before, when the proposals become rules or laws, what people should do is seek legal advice and then ask yourself, what can I do to reduce that period that it will take me to get indefinite leave to remain?
Okay. So let me just ask you. So what is it? Is there any update on undocumented people who have children in the UK that would enable them to settle in the UK? Any recent update changes on that one?
Now, we always say that we don't condone overstaying, but under certain circumstances, people may end up overstaying. Now, if you have a child, if you are undocumented and you have a child in this country, now it's important to realize that the rules keep changing. Now, when the rules change, they don't normally affect what they've already put in place for the children. So, for instance, with this proposal relating to indefinite leave to remain that the Home Secretary was talking about, they didn't talk about children. It didn't relate to children. It didn't make reference to like the qualifying period of a child born here, the period that a child can use before they get indefinite leave to remain. So, for instance, if a child was born here and has lived here continuously for 7 years, that wasn't touched, that wasn't talked about. So, if let's say, so I always want to let people know that, look, when it comes to children, they also have rights independent of the status of their parent. So if the parent hasn't got status in this country, look at the child's circumstance. Was the child born here? Now, if the child was born here, for instance, after they've stayed in this country continuously for 7 years, they can apply for indefinite leave to remain or limited leave to remain, depending on their circumstances. If the child lives here continuously for 10 years, they can register as a British citizen. Now, this is by operation of law under the British Nationality Act. So these things keep changing day in and day out. Okay, so it's important that people keep themselves updated in relation to these children and stuff like that. And when these children get their status, then the parent can also now make applications as primary carers of the children. But these rules currently that they are proposing does not seem to affect the children directly in a negative way. No.
Okay. So are there any other tips that people need to be aware of regarding recent changes? Most of our audience are people that are looking to settle in the UK that haven't got settled status yet.
Now, I always start by letting people know that keep yourself informed. Okay. Now, there are so many information going on online. Now, if you are not certain, just go back and read the immigration rules. It's on Google. Just type Google UK immigration rules. It will pop up and then you can read. But if you cannot do that one, then always seek legal advice. What I tell people, especially if you are here and you don't have any form of status, seek legal advice. Try speaking to people who can assist you and give you adequate advice so you can regularize your status in this country. Because bearing in mind that what is going on here currently in the United Kingdom with all the political upheaval and everything, people speaking up negatively about migrants and stuff like that, you can't just be there without regularizing your status. Seek legal advice now. People who have been here for at least 20 years continuously, lawfully or unlawfully, you can apply for limited leave to remain. That is something people have to bear in mind. Now, what we realize is with those people, they don't seem to have documents to confirm the length of time that they stayed in this country. But seriously, if you come into this country, at least have your name on a utility bill, something, because you need to be able to prove that for every year that you've been in this country for that 20 years, you have evidence. You need to prove that period as well. So it's important that people keep their documents updated and keep all documents safe. Don't throw them away thinking, oh, if they arrest me or something, they can find my documents. They would, no. If you can scan them, keep them in your email. It's very, very important because you would need them when you have to prove that you've been here for 20 years. Now, there are some people too, whilst they are here, they get married. Okay, so if you genuinely fall in love with someone that you really care about, then you can get married to the person and then you can make an in-country application depending on the status of the person. So for instance, if the person is a British citizen and they have a child, a minor child in this country, then of course you can do an application in country, but they will put you on the 10-year route to settlement. Now, it's important to talk about how you get married. Now, sometimes some people will decide to get married in the UK here. Sometimes some people will decide to say, look, I'm from, let's say, Ghana, so I would want my family to get involved and do it. So just bear in mind and think about the laws governing the validity of marriages. It's important to point out that the basic law, when it comes to international law, the basic law governing the validity of a marriage is the laws of the country where the marriage is celebrated. So if, let's say, the marriage was celebrated in Ghana, and Ghanaians in Ghana, the marriage is valid in Ghana, it would normally be accepted by United Kingdom. If the marriage, for instance, was celebrated in Nigeria and it is recognized in Nigeria and accepted as valid in Nigeria, if you're able to put together certain documents and prove that it is valid in Nigeria, UK would normally accept it, but it's a case-by-case basis in relation to those things. So everyone who is here who hasn't got any documents or anything, seek legal advice and try and regularize your status, because things are not going to be as easy as we in the past. Things are changing. So the earlier you regularize your status and make use of the current rules, the better, because you never know what will happen in future.
So just to make sure that I understood you clearly, say for instance, you have Andrew and Bola, they are from Nigeria, right? Mm-hmm. They met in the UK. Bola has UK settled status, Andrew doesn't have, and they decide they want to get married, but they want to do it back home for the representative marriage. Mm-hmm. So if that marriage was held on their behalf, the UK Home Office will recognize the marriage certificate as long as it's valid in Nigeria. Is that what we're saying?
Now, as long as you have to satisfy the validity requirement, okay, of the country where the marriage was celebrated. So if, for instance, in Ghana has got a uniform law, okay, so it's easier proving those things from Ghana. Now, I'm not sure about Nigeria, but the baseline is the marriage valid in Ghana? Is the marriage valid in Nigeria? Now, then you ask yourself, what are the validity requirements of the marriage in Nigeria or Ghana? Has all of them been satisfied? So if there's a statutory declaration that says a parent was present and signed, are there pictures to show the parent was present? Okay, because some judges may ask for those things to verify that what you stated in the affidavit or whatever comes with the document is actually genuine, okay, or it's actually the truth. So you have to make sure that all the validity requirements in the country where the marriage was celebrated has been adhered with, and then you can now say, okay, you've jumped one hurdle. It's valid in Ghana, it's valid in Nigeria. Now let's come to United Kingdom. Will they now accept it? Normally, if it's valid in the countries where the marriage was celebrated and the people can prove it, then UK would normally accept it.
Okay, that's fine. I think the question this gentleman just asked, you need to watch the video again, because that's the question that we just answered now. For anyone that wants to contact Laurentia, her contact number is 018-2733-7791. I repeat, 018-2733-7791. I will leave her contact details, her email and telephone number in the contact section for you to contact her. She's an experienced lawyer and she knows what she is talking about. Okay, so Laurentia, thank you so much for joining us today. We're going to end this session. It's very brief because Laurentia is a lady. She's got a lot of appointments. Even John Mahama is begging to speak to Laurentia. Thank you so much, Laurentia, for coming to speak to us today. Thank you, guys. Don't forget to